Golobe v. Alchek.
May it please the Court, Leslie Corwin. I represent Daniel Mielnicki in his capacity as the successor trustee of the Emil Kraus Trust. I respectfully request 5 minutes in rebuttal.
Yes.
Thank you. Respondents did not and cannot possibly present clear and convincing evidence of the requisite hostility, open and notorious elements of adverse possession. I respect that it is simply impossible for respondents to prove that the possession of these premises at issue has been adverse to the interests of the trust for the 20-year period for adverse possession in co-tenancy, because it is undisputed that the respondent himself was unaware he owned the premises as a co-tenant in common until after the statutory period passed and had become aware of the co-tenancy.
So why does that matter? Why is that relevant to adverse possession?
Because under the statute and New York law, there is a presumption that a co-tenant, which it is conceded, Judge Rivera, that there is co-tenancy here in this record, that once you concede that the other tenant under New York law, and that's the doctrine under Myers v. Bartholomew, holds it for the benefit of the other co-tenant, so that anything that was done here was for the benefit of the trust.
What about the 20-year statute of limitations for adverse possession for
I'm sorry?
co-tenants? The 20-year statute of limitations for co-tenants under adverse possession, why doesn't that apply here?
Because during that entire period of time, there was not adverse possession, because there was never the intent when this plaintiff took possession, he didn't think that he was doing this adverse to a co-tenant. He didn't know of it.
Isn't that always the case with adverse possession? I mean, now you're looking at tenant's state of mind, right? So in an adverse possession case, co-tenant, I'm taking possession because I think it's mine, right?
No. Under this scenario, Judge Garcia, he took it because it went intestate. He submitted to the surrogate's court of New York County that there was only one heir, his father, and then he deeded the property to himself, believing that there was nobody there. So he went in a state of mind that he didn't know of the co-tenancy.
You're not saying that that was a bad faith belief, right? He really believed he was the only owner.
No, that's where we have a problem here. It was unreasonable under the circumstances that are in this record that there was no semblance of any investigation that was ever conducted.
Wasn't there a judgment?
Whether that was pure negligence or
Wasn't that
fraudulent.
reasonable enough for the surrogate to give title?
No, the surrogate did not give title. That's the issue here. He gave himself title. All the surrogate did was issue letters of administration. And if you look at the timeline here, it is critical of why I believe this was not only unreasonable, but possibly fraudulent. Dorothy Golobe dies on February 24th. By March 10th, they are in court with a petition to appoint the son as the administrator. In that petition, and it's in the record, if you look at the record...
Is there something problematic about that window of time?
It's very problematic. How could you, in 2 weeks, have conducted a proper air search? Their own attorney who did this.
Well, it depends on what a proper search includes, right?
Clearly, nothing was done here. And in fact, nobody went to the court records. Nobody looked at the probate files. Nobody looked at Social Security records. Nobody looked at death certificates.
Just to pursue that for a minute. So in a typical circumstance where someone passes away, if I have a good faith belief, let's say I'm an only child, that there are no other heirs, do I have to, in your view, go through all of those steps? This was at a time, I believe, when an internet search was not available, so we can set that to the side, I think. But does someone have to go through all of those steps?
Yes, they must do at least a reasonable search, and they cannot, and that's what in the record.
Just to make sure I understand, so if I'm an only child and my one remaining parent passes away, I have to go through all of these steps to confirm that neither of my parents had another child that I was not aware of?
But
That's
he was
surprising to
aware
me.
of that. He was aware that there was an uncle, and in fact, he presented false testimony to the surrogate's court.
Knowingly false testimony?
I believe so, because
What-
if I may, at page 71 of the record, and this was by a referee in surrogate's court, this is 2 weeks after she dies. At the time Dorothy Golobe died, were both of her brothers living? No. This is the person who testifies. Only Zangel was alive. Do you
Okay,
know
so
approximately?
your point, I take it, is that there has to be some further effort to confirm that there's no one still living, but
Correct.
not that there might be other possible heirs out there of which no one is
That's the
aware.
first reason where they lose. The second reason where they lose
I
is...
just want to make sure I understand, which of those two is it? Is it that, in your view, the search has to include checking to make sure, just let me finish if I can, that no one, that there's no one still living, or do you also have to search to see if there are additional relatives out there that no one's aware
No,
of?
it's the first, Judge
Okay.
Halligan, but here they completely misrepresented. What they also did in that petition, which is where I find it very interesting, is that in that petition, if you look in the record under the petition that's filed, they stated, they don't even list that there's real property here. They say there's $160,000 in cash, and that's it, and they say there are no other relatives.
Counsel, you know, you spoke about Myers and Myers with the 10 years and plus 10 years, and I know you're familiar with it, gives you 20 years unless there's an ouster. Under your view here, there would be no running of the statute of limitations. At any point, 30, 40, 50 years later, somebody could come in and say, hey, wait, you didn't do the right amount of probate due diligence.
Correct, because neither of what we now know it's conceded were co-tenants was ever aware of the fact.
So
The
it could
only
be
time-
100 years.
Correct. The only time it comes into play here, and that's what's interesting also, is that 2 years before he starts the action, he goes to the
Doesn't
trust.
that original point somewhat cut against this idea of finality in titles, right?
No, it doesn't. In fact, if you look at, I respectfully submit, I know of no case in this state where it's conceded that there were co-tenants, and where under Bartholomew and the statute, RPAPL 501,
Do you know of one where
554.
they let them go back more than 20 years because of that?
That's correct. Because
Where? What case?
No, there is no case that says that, but what the cases do say is that where you have co-tenants and it is conceded, every other state that has addressed this issue has held that there cannot be
But our
adverse possession to
statutory
the
scheme is
possessor.
somewhat different than that, right? Our 10 plus 10 and Bartholomew Myers, the cases I looked at that you cite are somewhat different statutory or common law.
All the statute says, Judge Garcia, is that, and that's under the Trevesino case, is that it triggers the fact. It doesn't guarantee that it's adverse possession. It triggers an inquiry into it. Under this record before this court, there can't possibly be a finding of hostile intent
Under
because...
our statute, I'm sorry. Under
No, go
our-
ahead. Go
Our
ahead.
statute, do you need ouster? Not this case, let's say a regular co-tenant case. Would you need ouster during the 10 plus 10, or do you get 10 plus 10, you're
No,
done?
you would need an ouster during some time. That's what the statute says, but
You need an ouster under our statute.
Right. The appellant here had no opportunity first of all, the owner here had no opportunity to try ouster because didn't know about it.
The way I
and-
read our statute, the New York statute, is you can have an ouster, which starts your 10-year statute of limitations running, or you get 10 years. And then you get another 10 on top of that. So without an ouster, you get 20 years. With an ouster that's less than 10, you get whatever the ouster period of time, you run from the ouster 10 years. So 5 years, you have an ouster, it's a total of 15 years. That's different than other states to me.
No, I respectfully submit. I mean, take the case in the state of Montana, and I'm,
No,
I like-
let's stay with adverse possession in New York. Let's not go to Montana.
Okay,
Because I
but-
think the question is about the way our statute reads. Myers, I thought, it starts out, Judge Kaye starts out saying, we're going to resolve a question that's perplexed people. It's 20 years.
Period.
Correct, but there hasn't been adverse
So let's
possession
talk,
here.
but I just want to clarify here, because I think it is concerning when you say there's absolutely no end in sight. So let's just be a little bit clear here. I take that your argument only refers to a situation where you have co-tenants and neither one knows about the existence of the other, not because they don't know who the person is, but they don't even know it's a co-tenancy.
Right.
That's what they don't know.
Right.
Right? And so the person who's the non-possessory co-tenant for the moment, we'll just call it that person, has no reason to think there's an ouster, has no reason to go looking for anything. And the person who's the possessory co-tenant would never act on an ouster because they don't think they need to. They think they hold it in fee simple. Is it? I'm just trying to get straight what this argument is.
Correct,
And
that's
if
it.
that's your argument, then is there ever an end in sight?
There's an end in sight once there's a confrontation.
Well,
And-
what if
and
that doesn't happen until 100 years later?
then I say you can't have adverse possession under this fact pattern here. You could never have, it could, as Judge Garcia said, you could go out, this could have gone on for 40 years, but once the point in time, and the irony of this thing, the whole thing comes about because they go to try to sell this property, which is maybe even more valuable now than when all this studied because it's in the Penn Station relocation thing. And very quickly, a title company and a real estate broker pick up on the fact what happened to Yale. He was an heir. Now, the fact that that's picked up on so simply and that was never picked up on,
Could
that
perhaps
that what?
there be a limit in sight, given just the parameters of the way you've constructed the problem here and these two parties? Could there perhaps be a limit in sight if you're tracking back the possessory tenant's belief in the fee simple to some error in that chain, right? That they are going to be held accountable for. In your example, it's they didn't do their due diligence. That's
Correct.
why we've got the error to begin with, right? That, I understood you.
They
right?
never did due
And maybe
diligence.
that's your limiting principle, that just two co-tenants, for whatever reason, they don't put blame on anybody's shoulder, they don't really know they're co-tenants. Maybe there you've got some limiting principle under adverse possession. But when one person who benefits from it, in your argument, is the source of the error for themselves and for the non-possessory co-tenant, there's where you say the adverse possession statute has to give way. Am I getting?
Yes, that's exactly it. And whether it was just negligence that got them there in the first place to this building where they never should have been, or it was outright fraud, I'll leave to this court, and all I ask you to do is...
Sorry, I don't understand how you could conceive of it as being fraud, right? If you start from the proposition that neither knew of the other. If he didn't know the operative fact, how can that be fraud?
Because I will tell you, if you look in the record here, when I took his deposition, he said that he did nothing to investigate of whether Yale had died.
How do you deal with the Rules of Surrogates Court 207.16?
Which
says that the way you can prove where there's a sole person, a decedent is survived by only one distributee, proof of the death of others must be made, actually, by an affidavit or testimony of a disinterested person and shall include as an exhibit a family tree, table, or diagram, and that's exactly what the attorney did here, complied with that rule.
But
Why can't the executor rely on that?
Because they lied. That was it was untrue.
Those are two different things. Lying, and I do this with my kids all the time, lying about something and saying something that you believe to be true.
I respectfully submit, Chief Judge, that
Yeah.
putting something, and he did it twice, and I'll get to it. I asked this court to look at the record, to look at the petition between R 85 and
I'm asking
88.
a really much simpler question, I guess. When the rule says that, and there is something that complies with that, why can't the executor rely on that?
Because they didn't comply with it, in my opinion. They went to a referee, and it wasn't that the referee awarded the building. All the referee said, all the referee granted was that he could have letters of administration. And ironically, if you go through that petition at those pages that I just said, they don't even list the building in that as being an asset. So it shows right then they didn't know it
I'm
was.
unclear. You're saying that there was no determination in surrogate court that there was only one surviving heir?
I'm saying, what I'm saying is that he was entitled to be the administrator. He was granted the petition.
But isn't it
And
true
then-
that
and then
as part
his-
of that
then
process?
Then his father
But in order
renounced
to
his
become the
interest.
executor, he had to establish, part of that was the submission of the proof of who was still alive and who remained as heirs, which was submitted to the court and accepted by the court.
It was false.
So you're saying this Harold Kasposky was in cahoots to give false testimony to the surrogate
There's certainly
court?
an issue of fact with respect to that based on this record that's before this court
But the
right
surrogate
now.
court resolved that
How could
issue of
somebody
fact.
come out and nobody did any investigation, zero, within 2 weeks she dies in test
Well,
day.
you may be correct that more could have been done. And you may also be correct that perhaps the referee and surrogates court should have required more. But given that they didn't, can we revisit that in the context
You
of
don't
adverse
have to
possession? How does that impact the adverse possession analysis?
Because you don't even have to revisit that because you still have under the doctrine of the Court of Appeals decisions in Hinckley and in Bartholomew
Okay.
that there is a statutory presumption that any co-tenant holds the property for the benefit of the other co-tenant, and you could never get around that.
Get around
And that's
it in 10
exactly
years. You get around
that's
that in-
exactly.
But that's not how the statute reads. That lasts for 10 years.
Or 20.
No,
the
actually, if you look at
presumption-
Bartholomew, it says it goes for 20 years.
No.
And then all it does is it
I
triggers an
think
inquiry into it.
says you get this presumption for 10, and then the statute runs. That's how I read Bartholomew.
Thank you.
Thank you.
It pleases the court, John Brickman for John Golobe.
Counsel, can you indicate how, what impact, if any, the determination of the surrogates court to allow the acceptance of testimony that there was, that he had predeceased? How does that impact this case?
Well, it impacts the case because it determines who's entitled to notice of the proceedings. And it is a finding by a court of competent jurisdiction that there was only one surviving heir.
And who bears the burden of the factual error, which we now know there was not
Correct.
only one surviving heir? Who bears the burden of that error?
And I would be a little Talmudic and respond to the question with another question by saying, and for how long?
So I take it to mean that even if you acknowledge that the error occurred, and even if you acknowledge that the blame for that should be on the person who is asking to be the administrator, that exposure only lasts for 10 or maybe 20 years.
Yeah, I certainly concede there was an error. I'm not sure the blame lies with anybody, but I think we have to review in
Well,
order.
maybe it does. Maybe it does. I mean, if you go back to the Surrogate Courts Act that the Chief Judge referenced, it does say an affidavit, but the affidavit only has to include the attachment of a family tree. That's just to establish who the potential heirs may be, the heirs apparent. But that affidavit, does not resolve the proof for what anyone did to figure out if the uncle was alive and outlived the aunt. As far as I can tell, the argument was, he's 11 years older, he's in his 90s, he must be dead.
There's more than that. Remember,
Okay, tell
there's
me
a
what
wit-
else, tell me what else.
There's a witness at the hearing. There are several witnesses, but
Okay.
the primary witness is Harold Kozubsky.
Yes.
He's a lawyer. He's known Zhang well for over 30 years.
Yes.
He's known the family.
Okay, yes, he knows them all. What is his testimony that somehow establishes that he has personal knowledge of the death of the uncle?
There's two elements of his proof. One is at the hearing, and the other comes in the separate heirship affidavit. Let's stick with the hearing.
Whatever, either one.
He testifies that he knew Yale,
Okay.
that Yale was dead 6 or 7 years.
And he knows that how?
He's never asked that, and before
Well,
any...
doesn't, it's the burden, it's their burden to establish it.
But they're precluded when the court attorney referee steps in and says, okay, I've got enough.
And again, there may have been perhaps an error. So let's go back, I think, to where Judge Troutman was. How at all would that possible error impact the adverse possession analysis now? I'm going to Judge Canataro's question. Who bears the burden of this error when the error is based on the evidence
If there-
presented by the person who is going to benefit from the error?
If there were any evidence at all, rather than pure speculation and conjecture of bad faith, I'd have...
Well, even if there's not bad faith,
Well,
put
if there's-
aside the bad faith.
But
Put aside the bad faith. I mean, the uncle and his heirs have no opportunity. I could see if you came in and said they had all the opportunity in the world to challenge what went on in surrogate's court, but they can't. They have no information.
And the man who testifies at length that he's known the family, he's been friends with him, and by the way,
But it's not about that. It's what is the basis for saying, I have personal knowledge that the gentleman is dead?
he's
And I thought there was a lawyer who said, well, this is usually what we do to determine whether or not the person is dead, and none of those things were done here.
And that lawyer, when he testified in his deposition in the current era, couldn't remember what was done because it was 30-odd years
Did
earlier.
someone look for a death certificate?
I'm sorry,
Did
Your
someone
Honor?
look for a death certificate? You don't need internet to do that. Did anyone look for a death certificate?
We don't know that because the lawyer didn't remember. But I have to reemphasize that Kozubsky, the father, Harold, was...
Let me just ask you, was there a representation that someone tried to look for a death certificate?
There is no such representation, nor is there any evidence of whatever the precise diligence was. But when someone comes in and says, I've known this family for 30 years, I know these people.
So suppose we were to decide that the efforts made were insufficient. I understand you have a different view. What consequence does that have for the adverse possession question,
Well,
if any?
then maybe, and this, again, this is speculative, but I can't think of any other way to respond, Judge Halligan. Somebody would have gone back, and there would have been further efforts. But they might have called Social Security.
No, I guess I'm asking a different question.
Then I'm not following.
Sorry, let me try again. If we were to conclude that the efforts that were made way back were not sufficient to, adequately probe whether he was or wasn't deceased, and I understand you think it was sufficient, but if you have a different view, what consequence, if any, does that have for the adverse possession question in front of us?
And I'm saying that we can't tell because if it had gone back and more effort had been made, we still don't know if they would have determined.
So is your answer that it's irrelevant because it wasn't established? I mean, what we do know, in fact, is that it was incorrect, right?
Incorrect.
Yeah, okay. And
I agree.
Right.
I would have thought your answer to Judge Halligan's question would have been it has no consequence for the adverse possession.
Well, in the consequence of the passage of time, it has no consequence.
Well, let me try a harder question for you then, sorry, right in front of you. Suppose all of a sudden we had a letter between the attorney and John saying, we know Yale's alive, but I need a false affidavit from you, let's put that in. So we have clear evidence of fraud. How then does that affect and we're outside the 20-year period. What's the result then as to adverse
The
possession?
first day of law school, they taught us that hard questions make lousy law.
Yeah, that's hard cases, I think. Go ahead.
Hard case.
I still would like an answer.
I know. I mean, it might well taint my guy's position. But once again, we have a time issue here. And the law values the passage of time and certainty. I'm compelled.
Not that much more time past the 20, right? This is not 100 years.
Well, it's 30
Correct.
years. 1992, 26 years, 28
Sounds like a
years.
pretty cabined period of time.
I'm sorry?
Sounds like a pretty cabined period of time.
Pretty
Cabined period
cabin.
of time.
Yes and no. I mean, nobody who was around then, other than John, who's pushing 80, and by the way, has, as the record reflects, has had 2 strokes, compromising his ability to remember some of the events. I'd like to read something, a quotation in the court that I think really resolves, really is on point. We must be cognizant that every time we upset precedent, we upset people's expectations and the stability of law. It rocks the boat in a way that makes people uneasy about whether they're protected or not protected by the law. And that was in the New York Times yesterday, an interview with Justice Sotomayor. And while obviously the context was wildly different than what we're talking about here, it underscores the notion that what the law does has finality. The very reason for the existence.
But why can't the uncle rely on the law to ensure that proper efforts, due diligence is exercised, to try and identify his existence and those of his heirs so that they can share in the inheritance that they're entitled to? Why
Well-
are their interests somehow going to pay the price here for the error?
Well, the reality seems to be that the uncle absented himself from any involvement in the family, wasn't aware that his sister had died.
I don't think our rules of intestacy punish that way.
No, but I'm not sure that he's punished.
The only question is whether or not he predeceased her under our law. That's the issue.
Yeah, and
And he did not, as a matter of
He
fact.
did not.
Yeah.
But why do we have a 20-year statute? And I agree with Judge Garcia that it's effectively
Yes,
a
but
10-year
under
waiting
that
period.
statute, the co-tenant, the non-possessory co-tenant either knows, they both understand that there is a co-tenancy, or they have the opportunity to appreciate the possibility of an ouster. Here, there is none.
There doesn't need to be an ouster once the
No, I know
10-year
that.
period
That's the
passes.
additional 10 years. It's an implied ouster after the 10 years. That's how you get to 20. One is express and one is
Yeah,
not.
and that period passes and nothing happens. And while I don't think it's dispositive, I would point out that we have another fiduciary who enters the picture here in 2000, still during the unfinished period, and that is the trustee. And the trustee comes in, and he's the record owner of this chosen action. And what does he do to determine? I'm talking about Mr. Alchek, who was the current trustee's predecessor. What, if anything, did he do to determine whether there were any additional assets remaining in the trust for which he bore a fiduciary obligation? He didn't do anything. But I'm sorry.
So are you suggesting, as trustee, he had an obligation to go back and check heirs and see if there was something else that was supposed to properly be a part of the trust?
He had no lesser, well, let me say it differently. If he had an obligation, and I don't know, because I don't think that issue is posed squarely by this case, but it's pretty clear that if he had that obligation, he flunked it. I'd like to go back to something that Judge Rivera, you dealt with in some of your questions, and that is, why did Kozubsky know that, or believe that Yale was dead? He was a friend of the family, and we know from our own personal experiences that if you're involved with a family, you know what's going on, you learn things. Now, some of the things you learn are accurate, and some of them are inaccurate. And remember,
Big inaccuracy.
I'm sorry, Your
That's a
Honor.
significant inaccuracy, alive or dead.
But not one, notwithstanding the trustee's claim, not one of which there is a scintilla of evidence
Well, it sounds,
of bad faith.
sounds like also no evidence as to what the basis for his belief was, right?
Well, he
Other
testified.
than that he's a friend of the family, but more specifically, why he is of the view that he's passed away.
Why don't we take a look at what he, said?
Well, I think he said that he predeceased him by 6 or 7 years.
6 or 7 years. Now, in the heirship affidavit, he's even more specific. He says that Yale died in June
And
1985.
equally incorrect, right?
Precisely,
Right.
Well,
precisely.
If I'm understanding the affidavit you're referring to, all I saw was his name, a parenthetical, June 85. Nothing that suggests, maybe I missed something, nothing that suggests the basis for the 685,
I don't believe,
which I'm hard pressed to see how that could possibly satisfy the Surrogates Court Act,
but
here we are.
the court, here, perfect, exactly right. Here we are.
So we're back to the question of what, if anything, does that potential error, how does that affect this analysis with respect to the claim under adverse possession?
I
To
think
hold this
if-
in fee simple?
I think
moving
if you
forward.
let it affect the claim for adverse possession, you destroy the finality of adverse possession as a mechanism for the resolution of claims.
Even as narrowly defined for purposes of the unique circumstances here,
What title company is going to write insurance in that circumstance anymore?
I'm not sure what you mean.
What
by
that means is you're not going to be able to convey, remote grantees are not going to be able to
Well, they
convey.
weren't willing to move forward with this sale because they found them. Apparently, they could easily find out that there was an error.
But they weren't willing to do it, and now that there's going to be a judicial resolution, depending on how it turns out, they will sooner or later be prepared to write insurance. But if the sword of Damocles hangs over these circumstances, and saying this is an unlikely case or a remote
Yeah,
possibility.
but all I'm saying is, why should the uncle and the heirs pay this price when they were both laboring under this misunderstanding? So both could not act in the way at the point of that statute intends and seeks to incentivize them to act.
Judge, if you and I enter into a contract and we have a mutual mistake, and we put in there that you're going to pay X, when we really both thought you were going to pay Y, you have 6 years to move to reform that agreement. And if you don't do it within that 6-year period, you lose, even though you were right. Why is this circumstance?
I don't understand, because in your example, we both knew about the contract, both voluntarily entered this agreement. We both faced the consequences
We
of
were
a breach or
mistaken.
not, or the statute of limitations.
We were both mistaken. In the other case, everybody was
We both know we're in a
mistaken.
contract, in your example,
Well, all I'm suggesting is that statutes of limitations are there for a reason,
yes, they are.
for finality, for certainty, for repose. And the law puts a great value on
They're
that.
sometimes told based on the conduct of the parties.
I'm sorry, Your Honor.
They're sometimes told, T-O-L-L-E-D.
Yeah, of course. Yes, of course. But often, it's when a party is incompetent, or perhaps when a party has acted in bad faith. And again, there is no, I mean, it's a claim, but there's no evidence at all of bad faith here. As much as the trustee may have sought to argue that, it's just not there. Unless the court has anything more to ask me,
Thank you.
I'm going to rest.
Counsel, can I ask you, how important is it to your claim that these are co-tenants? Is that a key fact here?
Absolutely. Absolutely.
So let me ask you a hypothetical. If, in this case, this is a hypothetical, I know it isn't the facts here, but
Right.
if your client had been entitled to the property, the will said the eldest surviving, sibling or child gets the property. Same facts that come in, the eldest child's dead, it goes to the next one takes sole possession of this land. Under the same facts, just different will, right? And now, 10 years, 20 years later, come in, they say, no, adverse possession. Would you have the same argument?
No,
or
definitely not, because I knew about it.
No. Same facts as here. Nobody knows anything, except your client would be the sole owner of the property under the will if they knew that he was still alive. Not a co-tenant, just sole owner of the property.
Okay.
That changes things for you?
Yes.
Why?
Because for there to be adverse possession, it goes back to the questions you asked initially. There was no, and I say this record is completely devoid of any hostility.
Right.
Because how could you be hostile, either party be hostile, when neither party knew about it?
Scenario. Neither party knows. It's just the will says this person now takes everything. Your client was entitled to everything. Neither party knows they were entitled to anything, that the other person was entitled to anything.
What this court says, and what the statute says, and this is Myers v. Bartholomew, late Chief Judge Kay, says that there's a statutory presumption that a tenant in common in possession holds for the benefit of the other co-tenant. The presumption is that it lasts for 20 years rather than 10 years. We got into that discussion. And here's the key thing, because it goes back to the example you gave me.
Well,
the expiration of the statutory period.
The statute actually says this presumption shall cease after the expiration of 10 years.
Right.
So the statute sets up a 10 plus 10, and that goes to a tenant in common in the timeline.
Correct. But then the last...
Why, under these facts, if you have the same representations in surrogate's court, except the result is your client would be entitled to everything, not a tenancy in common, would that make any difference?
No, because the expiration of the statutory period only triggers the possibility of adverse possession. It doesn't establish it.
I think we're talking past each other. So why, in my hypothetical, would they have adverse possession, but if it's a co-tenancy, they wouldn't, after the expiration?
Because there would be nobody adverse to under your scenario. There is nobody adverse. There was only one person who had it.
In his example, the wrong person had it.
Right.
So
But there was nobody adverse.
The right person would be adverse.
The person who was supposed
your
to be.
client
Right.
would be adverse
Would
in
be
that
adverse.
hypothetical.
And if that, my client then found out about it.
Right.
And really was, as a matter of law, which is the case here, a co-tenant, then there could never be adverse possession under that scenario.
But what if he was entitled to be the tenant, the sole tenant?
Because that's what the will said?
Yes.
That would be a different scenario,
That would be.
if that's what the will said. But you got to understand, she died intestate here. There was no will.
No, but in my hypothetical, there is a will.
But there's a will. Then they're entitled to it. That's correct.
Who's entitled? I'm sorry,
If the will said that you're entitled to possession, then you're entitled to possession.
The oldest
And-
surviving
and
child
you keep it
is-
for the 20
I
years.
believe,
of
I
the
believe the hypothetical is, we'll just take two children, we'll make it easy for the moment. The will says the eldest child takes it all. They've won the lotto. They're getting everything.
Yep.
Okay? But they are not in possession. So they don't take possession. The other child, who's not entitled to a blessed thing, if I'm understanding this hypo correctly, under the will, takes possession. So I believe Judge Garcia's question was, does that make a difference, that they were not co-tenants
Yes.
at all? Because under
your
this appeal, they both had an interest in the property,
Correct.
50% interest. But in this hypothetical, the person in possession under the will has no interest. Have I got it right? I just want to make sure.
Okay. Under that
Do you now
scenario-
get this hypo?
Yes, under that scenario, it would be adverse possession because that other tenant, the one who knew and had it under the will but did nothing about it, should have protested during that 20-year period.
Judge
There was no opportunity
I didn't
here.
explain this hypo properly. Assume, for purposes of this hypo, that the non-possessory fee simple owner under that will does not know there's a will, does not know that they have this inheritance, correct?
Yes, and the
That's
first
the-
child says they're dead.
The non-possessory tenant?
Doesn't know about the will, doesn't know they have an
And
interest.
the will says that that person is entitled to it?
Correct,
Yeah.
Yes.
yeah.
Okay.
And the other child comes in and says, no, that person's very old, they're dead.
Yes.
Same facts.
Doesn't know about the will, that that's what it said?
Right.
Oh, I don't know, that's his hypo.
Right. Then it can't be adverse possession.
It cannot be. So
It cannot
co-tenancy
be.
doesn't matter. So it doesn't matter if it's a co-tenant or not. It just
Yes,
matters.
it does. It does. Because there was a legal document that said what was supposed to happen. That's not the case here.
It matters this way, it's 10 years, not 20.
Right.
Correct.
Thank you.
Thank you.